Hi, good morning.
Hey, good morning. I hope everybody's doing well. All right, thank you all so much for being here. It is 9:01. All right, perfect. I'm gonna hand it, good morning, everybody. By the way, my name is Teresa and I'm the Director of Communications and Training, and I'm gonna hand it over to Gwen Cadis, our Director of Policy.
Good morning, everybody. So great to see you here. We are joined here today with by Sheila Lewis, and she is going to talk with us about extreme risk protection orders. Sheila has been quite active in domestic violence and sexual assault for over 30 years. She served as chair of the parole board. She's been a bill analyst in the legislature. She's been an expert witness. She's done all kinds of things, and we rely on her quite heavily for her guidance and wisdom that she's gained over the years. And I'm going to hand it over to you, Sheila, and let you take over.
Thank you. Thank you very much. I just want to check the sound level. Everybody can hear me okay? Okay, great. Good morning. It's wonderful to sort of see you. Mostly I'm seeing boxes, but I assume there's people behind the boxes. And I'm very excited that you're all here. I don't know what your roles are exactly, but this is particularly helpful, I hope, for people who have direct contact with clients. But if you do not, if you do not have direct contact with clients, I hope it's helpful in your life as well. So I'm going to jump right in here, and I am a co-host, so let me get this out of here. And where is it? There it is. Okay, are you seeing a screen coming up? Okay, great.
Yes.
So this is a presentation about IRFPO, which we always call IRPO, but I was corrected. There has to be an F in there. I find it a little awkward, so I'm going to call it IRPO anyway, but technically the real name is IRFPO because it has to have the word firearm in it. And the one thing I want to really communicate during this time is that it is about extreme risk. This is an emergency order. So what I hope we get through today is how they work and why you should care. Okay, first of all, this is being used for emergency purposes only. And the reason why that's so important is because this kind of an order of protection is done, the first phase is done without the respondent having notice. The respondent is the person with the firearm that you want to take out of their hands. They do not have notice. This is all happening in court before they know about it. That's a big difference. Okay, what can an IRFPO do, or an IRPO? First of all, the respondent, the person with the firearm, has to pose a significant danger of imminent personal injury. So this is not the kind of order of protection that you could use for this has been an ongoing terrible situation. Nothing's changed. He's just a scary guy. This won't work. Something new has to have triggered it. You have to have sort of a threshold of something happened very recently. And as a result of this person having a firearm, they pose a threat to themselves or others. And the big one for this is immediate action needs to be taken before the person gets notice. It's very unusual in the law to have a hearing without the person getting notice. So it's got to be kind of a big deal. Okay. Just like a regular order of protection, it's a civil order that prohibits people from purchasing or owning a firearm. But the court has to find significant danger to self and immediate. Those are the magic words you're going to use throughout this. Okay, so, oops, let me go back here. These are the major differences between them. With an IRPO, the first one is for 10 days. That's the one that starts out with nobody in court except the person asking for the IRPO. And then once that is granted, 10 days later, there's a real hearing where everybody is there, and the court can issue it for 1 year. Technically, with a domestic violence order, it's up to 6 months and may be renewed, but we know that judges put in whatever amount of time they want in these things. They're very creative about these. So that's not true with an IRPO. 10 days and 1 year. But with an IRPO, it can be reviewed at the request of the respondent, meaning that the person with the firearm can come in and say, you know, I was having a really bad time in October, now it's December and I'm doing a lot better. Can I get my firearm back? And also the statute says that it can be renewed for a year. Once again, a finite amount of time, not one of these creative things that judges do all the time in orders of protection. And both of them are done in the same court, the district court, usually where the family court judge sits. Okay. Excuse me. What's the standard of proof? This is a legal question that I'm going to share with you because it makes a difference for you to understand what the difference between the two orders are. Probable cause is probable cause to believe that a respondent poses a significant danger. Same words again, immediate harm. Okay, probable cause means more probable than not. That means 50% plus 1. It's a little bit or any amount more probable than not. Beyond a reasonable doubt, which is what you're used to in your criminal cases, is humongous. The person cannot be convicted if the jurors find they have a doubt for which they could give a reason. A doubt. It's not a scale. It's a doubt. This is a scale. So this is much easier to get. You can see the standard is way lower. Okay. So now we have to talk about who can do this. The reporting party gets the ball rolling. The reporting party is the one who knows what this person did that requires this emergency order. And I want you to notice the shape of this rock here. This is not a smooth, round rock that's easy to push. This is a tricky rock. Okay. Who are the reporting parties? They're the usual suspects that you're all used to from your family orders of protection. In New Mexico, we define family really broadly. We let everybody any kind of kin in. We also let ex-boyfriends into this, ex-girlfriends into this. It's a big group of people. Those are the listed reporting parties in the statute. They listed 2 other categories, which I just find poor drafting. And I just want to say one thing. I did work on the domestic violence order protection bill, and I think it's well written. This one I didn't work on. I would never let this happen. But when it says school official, it doesn't say who's school official, current school official, which school official can be, does the head of security or the kid's teacher. It's totally vague as to what that means. And the same thing with employer, totally vague. The employer can be current employer, past employer. Does it mean somebody you cut the lawn for? I don't know. It's not clear. So that was not great drafting, but it leaves the door open for a lot of people. But here's the most important thing of all. As the bill is written, it says a reporting party includes. That's the magic word here. Why add the word includes? Well, frankly, because they made a mistake. Because I was at the legislature and there was a lot of talk about whether it should just be family members or not family members. And it was definitely the legislators' belief that they were just listing family members. However, either a crafty person or a crafty drafter stuck in the word includes, and that's magic language. And what it means is includes, but is not limited to. And it's just a list of people they felt like putting in, but really what this statute says is everybody on the planet Earth can be a reporting party. Obviously, when you read the statute, it doesn't appear that way. It seems very clear to everybody that this is a list of people, but that is not the case. And it's not just me who thinks that, because the Attorney General about, I don't know, maybe 2 weeks ago now, issued an opinion, and he says the exact same thing. Includes means includes, but not limited to. So that is one of the reasons it's so important. I think it's so important for me to get out there and explain this to people, because most people think, well, it's pretty narrow little law. The reporting party has to be a family member, but really it's big. Okay, there's another person in this statute that is called the petitioner. Usually the petitioner is the reporting party. And like the domestic violence case, right? It's the woman who wants to have the order of protection. She is petitioning. She is asking for it. In this law, it's a specific person. It's a law enforcement person. Once again, when they drafted the statute, they were a little either super clever or a little clumsy, and they defined a law enforcement officer to include an ADA, an assistant district attorney. And this is really important because A, the district attorneys had no idea that this was in the statute, and they are all shocked when I come in and tell them, hey, guess what? You are somebody who's supposed to petition the court. It's not law enforcement officers. And it's really important because a district attorney also has an advocate in their office and an investigator in their office, which means there's a lot more support for the reporting party who's going to come to them and tell them why they think this order of protection should be issued. When you go to a law enforcement officer, you're asking him to do work which really is beyond the scope of what he's trained to do. And it's not his cup of tea, frankly. So one of my goals in doing these trainings around the state is to make it clear to the ADAs that we believe that these should be handled by ADAs. And we're going to direct our clients to you, district attorneys. And you need to be prepared to do this because this is a lot. The petitioner gathers the information from the reporting party, prepares the affidavit, which fortunately is a form, which I'm going to send to you so you can see it. But the form is a checklist, so it doesn't require a whole lot of writing, which is great. The assistant district attorney has to get it notarized, which I thought was really interesting because the statute doesn't say that the form has to be notarized, but the notary statute says that anything that has the word affidavit on it has to be notarized. So that's the kind of thing a law enforcement officer might not automatically know. So it's great to go to an assistant district attorney to get that information. They prepare the petition, they file the petition, they argue the case, they ensure notice to the respondent, because remember, he's not there that first time. It's just the petitioner is there. and maybe the reporting party if they want to be there. And somebody has to support the reporting party. Many of you are advocates, I assume, and you understand how hard it is for somebody to report a family member, a loved one, even a close neighbor. Nobody wants to pull the trigger on something happening and maybe they're wrong. It's a scary process. But if you have an advocate to support you, it's a lot easier. And then, of course, this petitioner, the DA, has to be at the 10-day hearing. Okay, so I'm telling you all this because I urge you to go to a DA and not to a police department. What will happen if you go to a police department? If a police officer gets information from a reporting party and chooses not to file the petition, they say, I'm not so sure this is necessary. They can do that. They can stop the process right there. But the only consequence to them is that they must file, this is very strange, they must file notice with the sheriff in the county. The sheriffs have no idea that they're supposed to have a file called law enforcement officers who didn't go for orders of protection. They have no idea that this is a burden on them. So it's kind of a little vague. But that's the first consequence. What I want to also teach law enforcement officers when I present this to them is there is another consequence, which is that it says right in the statute that if they're wrong and they don't file the petition and something bad happens, they are liable. That was put in there in the same session that they worked on the other Immunity Act. And as you know now, people can sue law enforcement officers under state law. You could always file under federal law, but the court rules made it impossible for anybody to recover. We passed the state law at the same session. So this language is extra language. It's just because the two bills moved at the same time and nobody knew if both of them were going to go through. Let me be very clear for those of you who think it's unfair to police officers. I agree. Police officers can make mistakes and they shouldn't lose their house or their life savings from a lawsuit. The answer is they don't. They never have and they never will. When they say the officer, they mean the agency. And when they say the agency, they mean the insurance company. And that's who's paying this out. So you don't have to worry about if your loved one is a law enforcement officer that you're going to lose your house. That's not what this means. Okay, there's consequences if you go to a law enforcement officer. Those same consequences almost apply to the DAs, except that they have absolute immunity from lawsuit. So, in my opinion, going to a DA still carries a lot more opportunity for success than if you go to a law enforcement officer, because their resources are better and their skill set is more focused on this kind of legal stuff. Okay, what happens if you get an ERPO? It's a temporary order followed by the final order for all firearms, not the one that maybe was the reason the person was upset or frightened. And once again, you do not have to allege in the petition that a firearm was involved in the incident. Just that the person has access to the firearm, and that's what's making somebody very scared. If a person is the subject of the first emergency, the temporary order, the law enforcement officer or service or somebody who serves documents for the DA's office will bring that to their attention. They have 48 hours to turn over their firearm to a law enforcement agency. The DA's office is not equipped to turn it over, to store the firearms, so it's got to go to law enforcement or FFL, and we'll talk more about that in a minute. So when would a judge decide to grant one of these things? These are all the reasons that a judge might consider, the factors the court will consider. As you can see, they're the most logical things in the world. The person is upset and is using more drugs. They have an ERPO from before. They violated a court order. They don't seem to follow rules well. Obviously, threats of violence is the big one. But there's nothing magical about what triggers it. It's exactly what you think would trigger it. This is really, well, interesting because the last one in those boxes, if you didn't get that far, says, one of the things the judge may consider is any lawsuit, complaint, petition, restraining order, blah, 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 legal action between the reporting party and the respondent. I personally see a problem with this. Here's what the problem is in my mind. A lot of times the reason the respondent is more dangerous is because their partner has filed for divorce, or their partner is saying they want sole custody. In other words, because there's a lawsuit pending is the reason that the respondent is acting out. This is our experience across the board with domestic violence. We know that when something changes, it ups the ante. So how is the judge supposed to consider the factor that there's pending litigation? We also know from some districts and some judges that the judge goes, oh, I know what this is. This is her trying to get an advantage in the divorce or in the custody case. She's just trying to make him look bad. I assume I'm not saying anything that's new to you guys, but instead of saying the reason that now she needs the order is because he's gotten more agitated and is more frightening, they go the other way. Oh, this is just a tactic. So this is something we really have to work against with judges every day in domestic violence orders and in ERPOs as well. Okay, when you're going for a domestic violence order, you'll see that most of these things would qualify for a crime. Assault, suffocation, strangulation, bodily injury to household member, criminal trespass. Remember when we talked about the burden of proof for criminal charges is way high. The burden of proof for this is low. But in domestic violence orders, judges sometimes think erroneously that when you allege strangulation as a reason why you want a domestic violence order of protection, that you have to prove the strangulation occurred beyond a reasonable doubt. That's wrong. You only have to prove it's more likely than not that what I'm saying is true. It's a much lower burden, but sometimes judges get caught in it. And so sometimes that's why they are reluctant to issue orders of protection in the DV situation. The other reason that the DV order of protection is different is because it doesn't just cover firearms. It covers all kinds of things, telling him to leave, who's going to have temporary custody, what's going to happen with the property. It's a lot of things to decide in a DV case. So usually this brings people to the question, which one should I get? A DV order of protection or an ERPO? The answer is, what do you want? They get you different things. They both get you a firearm relinquishment. But with the domestic violence order, you may have other issues that your client wants to resolve through an order of protection, or at least get a court order on. One question I get is, can you do both? I don't know why not. Obviously, I wouldn't do them on the same day because the judge is going to say, why are you driving me crazy? But if things happen and you have a domestic violence order of protection and he has not relinquished his firearm, that's a very important time to go for an ERPO. Say, wait a minute, you told him not to have a gun and he still has a gun and he's highly agitated. This would be a good time. So that might be a situation where you're going to want to do both. Okay. Oh, but then everybody says, yeah, but relinquishment is not the same as seizure. Relinquishment orders the person to turn over their gun. Seizure authorizes law enforcement to seize the gun. And we know that people who are highly agitated, having a mental health crisis, they're not in great shape to follow orders. That's not what they're about at that moment. So it seems like relinquishment is kind of unrealistic to ask for. Okay, when can a law enforcement officer seize a firearm pursuant to a warrant? In other words, the law enforcement officer can go in and ask the court for a warrant because it's evidence of a crime. The crime is violation of an order of protection. Okay, so they can go to court and ask for it. It's paperwork and it's tricky, and not that likely that you're going to get a law enforcement officer to actually do it, but unless they're really frightened, and that might be the case. So it's only whether they have probable cause to believe that a criminal offense, that a criminal offense has occurred, and it doesn't have to be a felony. Okay. When can they seize a firearm in plain view? Okay. If the person is under an order of protection, they're told they can't have a firearm, but they still have a firearm. So it's evidence of a crime. Seems pretty easy. They should be able to just go snatch that thing if they can see it. But here's the plain view doctrine. Here's like a semester of law school I'm going to sum up in one slide. The plain view doctrine tells an officer that you can seize evidence of a crime if it's in plain view, if it's right out there, but you can't enter a residence or a vehicle and use the plain view doctrine. Why? Because your house is your castle. And of course, in New Mexico, your vehicle is your other castle, your castle on wheels. And many of us live out of our cars, so we have a lot of protection for our car. So that requires a little bit more if the firearm is in a vehicle or a car. Vehicle or a house. And that would be consent, might be one way. People say, well, why would anybody consent to a search? Because if you don't consent, they can't search and take your gun. Well, because most people don't go to law school, and they think that when a police officer says, okay, if I search your house, okay, if I search your car, if they say yes, the police officer is going to go, I was just kidding, just a test. Since you said yes, I'm not going to do it. No, that has never happened in the history of the world. If you say yes, he goes, thank you. And boom, everything is being searched. People give consent all the time, almost 100% of the time when law enforcement approaches them. So that's simple enough. Law enforcement says, I have reason to believe you have evidence of a crime here. You have a gun. You're not supposed to have a gun. Okay, if I search? Sure. They go and search and they take the gun. Okay. We already mentioned a warrant. There's a third category, which is exigent circumstances, which means basically OMG, something big is happening right now. That's legalese for that. But what are exigent circumstances? What would qualify as something that's urgent, immediate, a high risk of imminent harm to self or others? The facts in your petition. If you were successful in getting an ERPO, you have already laid out the facts for exigent circumstances. They're right there in writing. He started acting crazy. He pulled out a gun, whatever. So it really enables law enforcement in many more circumstances to seize a firearm, which may not be available in a domestic violence order of protection. And that is search and seizure law, that is constitutional law, and that is what an ERPO does. So now I want to leave this open for some discussion about what your experience has been with judges around orders of protection, around clients. There's one other thing that I wanted to tell you. I've done this presentation in hospitals as well. And of course, hospital people are emergency room people, security guards, mental health workers, and they often have that information. And when I tell them, you are in that list of everyone on the planet, they're like, wow, that's great, but I have a real job. I don't want to go to court and do all this stuff. I don't want to be involved in all this. You're not really involved in all this. The person who tells a law enforcement officer is basically the witness that is for the facts, but the law enforcement officer, the DA or the police officer, is the one who must go to court. So it's not as frightening as well for family members. They can go to court because they may have information the judge wants to hear, but they don't have to go to court. And we know that for a domestic violence order of protection, the person who's seeking the petition the family member must be in court. So that's another huge difference that will make this easier for your clients if they choose to go that route. So now that I've put that extra piece in there, tell me a little bit about your experiences with judges who have you've sought orders from. How do they handle these orders of protection? When family orders of protection. Well, let's start with the easy one. Anybody have a judge say, this is a tactic. She's just trying to get an advantage in her other case. Anybody have that experience? And how does one convince a judge that that's not true? It's not that I'm trying to get an advantage, it's that things got way worse. What things do you try to tell the judge? Well, okay. I think the kinds of things that people usually tell the judge is, really, judge, this is not somebody trying to get an advantage. Nobody has coached these children to allege sexual abuse against dad. It's almost impossible to coach a little tiny kid to make any kind of statement that is remotely credible to any other adult as a tactic to try to get after the person with a firearm. It's always the child made the disclosure, and now he's really agitated because now he sees, wow, I'm in a boatload of trouble here. If they believe this kid, I am in a lot of criminal trouble as well. So those are the kinds of things I think you have a lot of experience with. And you just have to kind of move them into another realm. When it comes up to that last box on the of things the judge may consider. It does not, by the way, the statute doesn't talk about whether an advocate can be there or not, but I don't see any reason why an advocate can't be in the room with the police officer or the law enforcement officer, if that's helpful. Doesn't say. The other thing you should know about it is there have been, as of a few months ago, there have been 5 of these filed in the whole state. 4 of them in the most conservative counties that oppose this law the most. Just as a heads up, when it works, it works. And the other one was because the judge didn't believe that anybody could file it. But now we have a better case to show that. Did I see Eric have a hand up?
Yeah, I just wanted to add, as far as I know, this has never happened in my jurisdiction, that one of these orders has not been put forward.
Where are you from?
In Eddy County.
I think there was one.
Okay, it must have been.
I think there was.
It wasn't in the, but it's, in my experience with dealing with judges, particularly in regards to protective orders, they're pretty open to hearing from law enforcement. If you come into the hearings and let the clerk know you want to make a statement that you have information about the case, you can get a lot in that you wouldn't get in a criminal trial, for example.
Right.
But
Yes.
It's just a matter of it. Unless you're really laser focused on that particular case, or domestic violence is something you're putting a lot of effort into, you rarely see officers do that. But judges the ones I've appeared on, they're usually very appreciative that you're there and that you're giving your views on it.
I think that that's really, really true because it's sort of rare for officers to come in, that when they do, they really have a lot of clout. And that's why we beg them, please show up, please show up. But, they have a lot of other duties. And also, I don't know, in Santa Fe, we're down 30 officers. So most people don't want to spend even 5 minutes on a Zoom call, let alone if we ever get back to reality and have to go to court. Anybody else have good experiences getting orders of protection? Gwen, what about you?
Well, I just have a question. So what can we do if, for example, the assistant district attorney or the judge is not familiar with this law and is not familiar with other than household members can file. Okay.
Well, good news, I'm doing a judge's training. That's one. But I think, I'm doing it district by district. So there'll be districts that say, I don't need to hear from her. I don't even know who she is. But the Attorney General's opinion was really a big bonus for us. Frankly, it was a judge, I believe in Eddy County, who was the one who said, I know what the word includes means, and I see it right here in the statute. And everybody's sort of like, really? Really? And sure enough, if you do the research, it's very clear. It includes means what it's, this magic legal term. But even then, it was still hard to convince judges. As I said, the one that didn't make it in Santa Fe is because the judge said, you're not a family member reporting party, so you're out of the ballpark. But now that they have the AG's opinion, and they're going to be talking about it, even if I don't get invited anywhere else but the first judicial district, they're going to talk about it because it's a big deal.
And I can also imagine that this could be helpful in the domestic violence order of protection process, where a couple of years ago, the coalition worked with others to get a firearm relinquishment piece put into the domestic violence order of protection. However, at the last minute, we had a friendly amendment to include that the judge would have to consider that there was a credible threat. And this is something that results in a lot of non-relinquishments. It's been, very, very, very low. And so I can imagine then that this might be something that could come in at that point if the judge does not order firearm relinquishment, and it's a danger.
That's right. Remember, the judge is thinking about a lot of things in the DV order of protection, and they're going to go, no, we'll skip that one. He can keep his gun. And one thing we have to always remember is everybody has the right to their firearms, and nobody wants to wants to get involved in that fight or violate that statute. They have their right to their firearm, but everybody, the most conservative gun advocates say, but not mentally unstable people, they shouldn't have a gun. And of course, it's, unless you go through an FFL, federal firearm licensee, other people will sell you a gun. They're not going to do that kind of check. And even if you have a mental health history at one point in time, you may not now, or maybe you were perfectly healthy your whole life and now things are falling apart for you. I didn't mention the FFL, and I meant to. So the other people who can be recipients of a firearm after they're relinquished are these licensed people. The respondent will have to pay that person to hold their firearm for them. But many people prefer to do it because they are more careful with the firearm. They are more respectful of the person's right to their firearm. So just so that the relinquishment might happen either at a police department or at a FFL. That's something to help the judge, because the judges sometimes say, our police department can't keep track of anything. I don't feel good about this guy having to relinquish his firearm to this police department. I mean, I don't know if that's true in other jurisdictions, but this is an ongoing problem in Santa Fe, that our police department has lost evidence. And if that's something that your judges are worried about, you just say, well, he can relinquish it to a paid professional whose job is to keep track of guns, not injure them, not confuse them with other guns. Treat them with the respect that they deserve, Your Honor. So.
And I think that law enforcement has had problems, or there's a barrier with storage of the firearms. And so this has been an issue that we've looked at. There has been a grant, at least one in Virginia, that provided money for storage, for creating additional storage for these firearms.
Right.
So we're looking at that.
I want to add one other thing. I don't think even after I train everybody in the state and I convince everybody this is the best thing since sliced bread, that it's going to increase to hundreds, 50s, 20s. This number is going to be very small. It's highly unusual that all these factors come together at the same time and that this firearm needs to be taken away. This is an emergency, high risk order. So I think storage is a bogus issue. You know, and one thing that is tricky for them is it can't go into the evidence side of the evidence room. They're going to have to create another locker somewhere because it's not evidence. So it has to be treated somewhat differently. I will be working with some law enforcement departments to try and come up with some policies and procedures on what to do with these firearms, who, you know, how to track them so that they get back to the person when they come in. All of that still needs to be done.
So what we did is we bought several firearms cases specifically for these instances, and you know we collect. There's nothing in them. I think there's one, maybe two cases that we've actually had guns brought to us, but we do have a special section in our evidence to store these. And I wrote up a policy and wrote up a sheet for the district court judges to give to somebody if they're going to bring us a gun. Things like, you know, don't bring it here loaded. You leave it in the trunk of your car. You come inside. You tell us you're here. We'll come out and we'll collect it from you. We don't want them walking into the lobby with a gun. Just some basic things like that. But really, we haven't had any issues with storage. Very, very little of it is used at all. And we run a background check on when the gun is brought in, and we run it again before we give it back to the person to make sure that they're eligible to have it.
Right. That's great. It sounds like you're way ahead of the game. And by the way, we've heard of a couple of them, and we checked with the administrative office of the courts. Say, how come your numbers are so low? And judges, I don't know. I have to really figure this out because I don't understand when you have a court case, at the end of the case, you enter it into the computer. I don't understand why the administrative office of the court doesn't know about a couple of these cases, but they don't. So that's something we're also going to look into. What does the judge do when they issue the order, and what are they typing in at the end? That this is not showing up as an ERPO.
So Sheila, I have a question for you. So I had an issue that this was back when the law first came into effect. I had a meeting with two of the different district judges, and one of the judges made the comment that if the violence from the perpetrator didn't include the use of a gun, they were not going to order that the gun be taken away from them. So, you know, you could have a strangulation case or, you know, aggravated battery, whatever. If the gun wasn't the tool, the mechanism, they weren't going to entertain taking the gun away. And the way I look at the law, that's not what it says.
That's not what it says. And I think that's a big mistake because we know that domestic violence escalates. So if he's willing to choke you out, he's willing to point a gun the next time. It's got, you know, it goes up. Rarely do people become less violent. So that's an important thing to tell judges is, do you see this pattern of escalation? The next one will be a gun. And I'm not saying that's going to be the shooting of a gun. It's more likely going to be an argument where the guy's cleaning his gun, or, you know, he just puts it in his lap and, you know, not even pointing it. The message is loud and clear. I control your life, loud and clear. So you really have to kind of work with judges to understand that.
Well, and I think it's important also to address the intimate partner violence suicides, because there may not even be a homicide. There may be a suicide that results from it, which happened here in Lincoln County a few days ago. And so just that fact is also something to think about. It might not be the victim who's in danger. It might be the offender.
Right.
And along with that, we are now reviewing intimate partner violence suicides within the New Mexico Intimate Partner Violence Death Review Team. So that will be some new information that we'll be able to disperse every year.
That's going to be great because anyone who's had a suicide in their family knows that it's often an attack, or certainly is experienced as an attack by the other family members, and it's a powerful attack. So it's very important. And of course, nobody wants a suicide. Nobody wants to see somebody so agitated that they feel they have no recourse, or that the only way they can be heard is to commit suicide. It's a horrifying state of mind for somebody. We want to prevent that as much as we can. So I'm really glad you're working on that.
Well, and just to consider that often there are children involved, even if they're not present at the scene, there are usually children involved in the family.
Yeah. And you can imagine how devastating a suicide is to a child of a, didn't I count for anything? Any other thoughts about this? Does it seem plausible? Do you think I love talking to DV people because you have gotten orders of protection, but when I talk to other people, they're like, "Oh, no, it's a law that can work for you," and I hope it feels that way to all of you. When I'm in the hospitals teaching this, I tell them, you're in the business of saving lives. Why wouldn't you want to do this? This is a piece of cake. Call up a police officer or an ADA and tell them why you think this person shouldn't have a firearm. You're done. I think we're getting through slowly.
It's another tool in our toolbox.
Right. Oh, and the last good piece of news is if you want to do one, you just call me up. Did you remember that old slide? Oh, it's still up there. That's me. Just call. We'll talk about it. Maybe you don't have enough. Maybe you'll tell me something that happened. I'll say, I don't think that's imminent or immediate enough. What recently happened? Or whatever. I think I can help you think it through. I'm not giving legal advice, but I can help you think it through. Any other thoughts or questions?
I just want to say that I'm really grateful that you're reaching out to the judges and doing this training for them as well. I think all around is fantastic. So thank you.
Thank you. Let's be honest. I don't think they listen to me that much. I give it my best shot.
All right.
I hope that all of you remember that in your own life, tragedies and disasters can arise. So, you may have somebody that you care about who you think is in a bad place in your own life. So I hope I've reached that other side of your brain, the personal side of your brain, not the professional side of your brain.
And also just to mention, if anybody wants Sheila to do this for their organization, please call her and she can do that. Right, Sheila?
Yeah, I love doing it for a whole agency, because I think you can support each other. If you have therapists and you have advocates, if they both know it, they both understand how this could help that client.
Right, perfect. I placed in 2 links in the chats. The first one will be your survey. If you can please fill that out. In order to attain your certificate for today's training, you must complete the survey. And after you complete it, it'll be automatically emailed to you. So it'll be a one and done type of thing now that we're doing at the coalition. So we're really excited to have that done. The second link is our YouTube channel. As mentioned, I will be uploading this recording to our YouTube channel that you can go in there and share with your colleagues and for reference, as well as Sheila will be sharing some documents that I will also be sending out to you in an email as soon as I get those. So please keep an eye out on that. Otherwise,
I just want to say specifically what it is I'm going to send you the affidavit so you'll see what the check marks. I'm also going to send you a document that you can share with your clients. It's sort of ERPO, for beginners to try and help them understand. If sometimes reading something helps So those are the items I hope to share. I'm sorry I interrupted you.
No, that's totally fine. Thank you for clarifying. And thank you, Gwen and Sheila, for making this training possible. And as Sheila mentioned, if you are interested in having this training for your program or someone in your area, please contact her. The more that we can raise awareness about this, the better, right?
Yeah, especially if you have a good relationship with your local law enforcement agencies, try and get them on the same training. Usually we do. We have pretty good relationships with law enforcement. So if you're at the same table at the same time, we can get a lot done.
Perfect. Gwen, is there anything else that I'm missing?
No, I don't think so. Thank you, Terry.
Thanks, Terry.
Right.
Thanks everybody for coming.
Thank you, Sheila. Very informative. I think this has really been helpful.
Thank you. I hope so. Hope we save a life. Thanks, everybody. Bye now.
Bye, everybody.